Mr. Chief Justice, may it please the court?
I want to ask you, because it's fresh, you don't get 3 minutes uninterrupted. I was listening very carefully to all the arguments. Mr. Waters was trying to defend the admissibility of the expansive nature of the 404B. And I thought he made a very compelling point, because one cannot fully understand, I think he used the word bowling point, without all of these interconnected parts. And so that's the logical connection that gives the judge the discretion to allow the fact finder to consider the evidence. So I'd like you to address that 404B issue, and particularly that position argued by the state.
Yes, Your Honor. I thought that the strongest point, really counter to that, was look at what was actually admitted. We had the victim impact testimony from the financial crimes, which I think the questions made clear have no connection. What did they connect to? Mr. Waters had a theme through his examination of all the witnesses. He asked every one of them, did you know the real Alec? Did you really know him? That was a question that was asked every single acquaintance. Did you really know him? You didn't really know him, did you? The theme there, clearly, was that you didn't really know. He's really capable of anything. He's a bad person. You don't know what he's capable of. And that's why that evidence was, that's why you had the mentally disabled, victim of a financial crime, which has nothing to do with the supposed motive of I need to conceal something because I might get caught, right? It has to do with you don't really know me. I'm a really bad person. And because you don't really know me, you don't know what I'm capable of, so please speculate that I'm capable of murdering my wife and my child. That was the purpose of that evidence. We didn't have, whatever it was, 12 days of financial crime testimony just to prove the fact that he stole a bunch of money and might possibly have had some fear that he might one day be caught for having stolen that money. And then the speculation is, well, he wanted a distraction, and we can talk about why this would, the logical leap to I'll just murder my family and be the center of attention, and how that's somehow going to get scrutiny off of me, obviously doesn't make a lot of sense. And I think he, more than most people, is in a position to know, given his background, that putting himself at the middle of a high-profile murder investigation is not the best way to distract attention from his own affairs. So I believe that's why that's the logical disconnect. And then the real reason that it's admitted is this trial theme that you'll see in every single witness who had a personal acquaintance with him. Every single one asked, did you know the real Alex Murdaugh? And that's why that was admitted.
Thank you, sir.
If I could, I would like to speak a little bit to the cell phone questions that both, I believe respectfully, maybe the factual predicate behind some of the questions might have been a little off. By way of very quick background, the iPhone has a database that records with a timestamp every time the screen lights up, every time it goes off. Various events will cause the screen to come on and off. An incoming phone call turns it on. It stays on for a period of time, it turns off. Incoming text messages, other kinds of alerts. And then there's this rise to wake feature, which is slight movement of picking up the phone causes it to come on and off. Now there's an entirely separate feature called an orientation change, which is it moves a different way enough to rotate the screen we've all seen from portrait to landscape, and that only happens if the screen's already lit. The importance of all this is Maggie's phone screen was lit continuously from about 9:02 to almost 9:07 p.m., right? So it's lit that whole time. It did not just suddenly light up at 9:06 and 12 seconds. At 9:06 and 12 seconds, what happened was the final orientation change, which was a process that took 8 seconds and ended at 9:06 and 20 seconds, right? And at that time, at that exact time, there was an incoming call from Alec Murdaugh, right? So it's rotating, someone's rotating it while he's calling the phone. Her phone was lit up that whole first 5-6 minutes because he was called her phone, I believe, 3 times, texted 1 time. It stays on for a minute after. That's why it stayed on the whole time. So it could have, if the issue is with the screen lit, it was lit at 9:04, 9:05, 9:06. So if throwing it out of the moving car causes the screen to light up, it could have been thrown out at any of those times. But it goes off before 9:08 and 20 seconds, which is when we now know, drove by the point where it was recovered. So the screen is off that whole time. It doesn't come on again until there's another call, 20 minutes later, right? So it's dark the whole time he passes it. So the issue is...
This is all directed at my questioning Mr. Griffin about the importance of the expert, of the testimony, the evidence.
Yes, Your Honor, absolutely.
Your answer is that it's important if the murder occurred between 9:02 and 9:07. Why is it important if the murder occurred after 9:08?
Your Honor, it's not when the murder occurred, it's when, after the murders, when a phone is thrown to the side of the road.
Right, but the phone wouldn't have been thrown to the side of the road before the murder.
Correct. The point is that at the time that we know for certainty the defendant drove past where the phone was thrown, the screen never came on. There's a long period of time before that when the screen is on continuously.
You make a great point. If all this occurred before 9:07, then my questions to Mr. Griffith were, as you pointed out, factually flawed. Mm-hmm. But if it all occurred after 9:08, now you answer the question, because I think the validity of my question is now squarely on the table.
If your question is, could it have been thrown out after 9:08 p.m., then the answer would be that would be inconsistent with the screen not coming on, yes. The point is the phone had to be thrown out before he drove past that spot. And that fact was not known until near the close of the state's case, right? Because somebody at General Motors was watching the trial, saw when the FBI agent testified on cross that they don't cooperate with murder investigations. Somebody took exception to that, and they produced accurate data, to pretty much every 3 seconds, not from his vehicle, but from a server General Motors keeps, far away, tracking his every movement, even though it was years earlier. And so all of a sudden, we know exactly where he is and know with certainty it's to the second when he drives past that spot, and we know that the phone is dark the whole time. So the question becomes, is it possible to throw the phone out at that moment without the light coming on? And as Mr. Griffin said, we don't know how it got there. Somebody could have stopped the car and gently put it out, but we know he didn't do that. So that's the central question. And the testimony from the defense was, here's the feature, everyone can see it. I'm not qualified to say whether throwing it from a car will cause it to do whatever. And we had an accident reconstruction guy who was qualified to say that. But then the defense rebuttal expert, they bring in a chain of custody expert from their direct who says, well, I threw it around my office, no one saw me do it, but I'm here to offer you what Mr. Waters accurately described as an expert opinion, that if it's a gentle motion, this is what it does, but if it's a violent motion, this is what it does, and this is why it's programmed to do and behave in that fashion. That's clearly expert testimony. It was well beyond his expertise. He was offered as somebody who knows how to use Celebrite to download the extractions that we've been talking about. And as to the preservation, it was immediate objections as soon as this came out. The motion was renewed the first time the jury left the room. The judge ruled, Judge Newman ruled for the reasons he gave in the record, which we assign error to. It was not an untimeliness ruling. So I don't believe that there's merit to the preservation argument there. The judge even said that the objection was preserved for the record.
Is there any dispute that Mr. Murdaugh called 911 20 seconds after OnStar recorded that he arrived at the scene where the bodies were?
No, there's the timestamps that OnStar produced and the 911 timestamps are not in dispute. I would note that the nature, it's a rural area, and just because you first got there, it's dark. You don't necessarily immediately see someone the first second OnStar says that you pull up, and you've got to get out and look, and then his phone is connected to the Bluetooth, Well,
what do you say to the state's argument that that's not enough time for him to do what he said he did, which was go check on the bodies, which were 30 feet apart? In
20 seconds, to look at two bodies that are 30 feet apart, I don't think that's impractical at all. I think I could, if you think about a pace is about 3 feet. If you're alarmed, and you could take a pace in less than a second, right? That's not, you don't even have to break a run to do that.
Can you respond to Mr. Waters' comments or argument about the clerk of court?
Absolutely, Your Honor. I think the most important point to point out with that is that there was absolutely no finding by Judge Toll that Juror Z was dishonest. That is not a finding.
She said she was ambivalent.
Your Honor, she said that only as to her response to the question forbidden by 606B about the influence this had on her deliberations in the deliberation room. She said she was ambivalent, whether it was that or pressure from other jurors during deliberations. There was no question of her credibility when she was recounting what Clerk Hill said to her before deliberations began. None. The only evidence presented at that hearing, the only evidence contradicting anything Juror Z said or the alternate said or that was proffered by the egg juror in affidavit, the only evidence whatsoever was the testimony of Clerk of Court Becky Hill. It was not credible at the time, and it turns out that Judge Toll, was good at judging credibility because it has since come out that she perjured herself at that hearing when testifying about a different issue, but about her conduct at the trial. So she was, the testimony of a perjurer at that hearing, admitted perjurer, is the only evidence contradicting the statements, the sworn statements from Juror Z, from the alternate juror, from the sworn affidavit of the egg juror. So our position would be that it is would be wholly unsupported by the record to credit that denial from Clerk Hill over all the other evidence in the record. That would, if that finding were made, which the state argues was implicitly made, certainly wasn't explicitly made, that would be an abuse of discretion. However, we argue that that wasn't implicitly made because Judge Toll didn't reach these sort of almost nitpicking, was this said versus that said. She found that her word exactly was improper. Improper comments were made to the jury. She found that it was a deliberate attempt to influence the jury, that she had a book deal. That was all found. But it didn't matter whether it was this comment or that because her decision was controlled by an error of law, which was essentially that the defense had the burden to show some sort of but-for causation to the verdict. It didn't matter because because it didn't affect the verdict. Whatever was said was improper, but the verdict would have been the same no matter what. That's the written order. And that is the error of law because the prejudice, which has to be shown, is the prejudice to the fair trial, which is that these things were said to the jurors, right? That's the bias, right? This was said to the juror. That's the bias. We've shown the prejudice when we've shown that it's been said to the juror because now we don't have an impartial jury. There's no need to show the effect of the bias on the verdict.
But he says the comments were fleeting and innocuous. And Judge Toll said limited in subject and not overt as to opinion.
Yes, Your Honor, and maybe to address a question I was asked at the very beginning, is that a question of fact or law? What was said, that's a compound question. What was said is a question of fact. Characterizing it as an application of law to fact is a mixed question. To the extent, you have to disaggregate it and say, well, what was said? Again, the only evidence in the record, right, unless you were to accept the found to be not credible testimony of Clerk Hill, who's also perjured herself, the only evidence in the record is that those don't believe the defense was said. Don't be fooled by the defense. That's the evidence in the record. All right, so given that said, to characterize that as neutral as to opinion is an abuse of discretion, and it is a misapplication of law to those facts. To find that that wasn't said would also be an abuse of discretion because it would be a finding wholly unsupported by the record.
Maybe one. Yeah. I'm just going to remark that it's not fair to you and Mr. Waters that y'all had to talk about every issue, and these other two deadbeats over here only had to talk about half of them. But are you good to talk a little bit about some of the real nuances of the tool mark?
Absolutely, Your
Okay.
Honor.
You put in in the pretrial hearing, or Mr. Griffin did, the theory of tool mark is set forth in several documents that have been widely circulated and published by the AFT and so forth. But there have been criticisms of those, and one of the most striking ones is this idea that the conclusion, how they reach a conclusion, is circular, and that makes some sense, really. But my question to you is, wouldn't you say that those criticisms go more to the application of the theory than they do to the validity of the theory?
Yes, Your Honor, if I could. It's important to, I think the best way to look at it is to compare it to DNA evidence, because it's so striking, right? Everything in the universe is unique, right? The tool marks are all unique. The question is, do we have a process that can reliably distinguish, the cause of this mark to the exclusion of all others, right? That's the actual question. I did this process, and I can say, with some degree of certainty that, these two tool marks are made by the same weapon and not two different weapons.
To shorten it up, I'm suggesting that you just asked a really good question. Do we have a process to differentiate? And I'm suggesting that these criticisms that have been published, particularly this idea of the circular thing, would answer that question. Yes, we have a process, and it works, it's valid, but it has to be meticulously applied. Is that a fair way of interpreting those criticisms?
It's certainly fair. Where I was trying to go with that is, with DNA evidence, as the court knows from the many DNA cases it's had recently, these differences are quantified, and you get a very, 1 in 8 billion or whatever chance that these, came from different people, that we say it's a match, right? Here, you have this very circular and very subjective. What you have in the end is two marks that look really similar, and somebody eyeballs them and makes a subjective judgment call that these two look really similar. And our basis for that is circular, because we say, well, I look at this part and that part, and it's like, well, how do you know that means they're the same? Well, that's what we've always done. That's what I was trained to do, and it's very circular.
The theory says you have to find whether they match. And the next question is, well, how do you know that? And you say you have to find sufficient alignment. And, right. Nobody ever comes down with a hard rule like you got to find 5 marks on the same cartridge that are identical to the 5 marks on this cartridge. Whereas with DNA, particularly with the ideas like touch DNA, you have the expert saying, I was able to identify 8 pairs of chromosomes, and they match to what was at the crime scene, or that to what we found from the defendant, and that gives a 1 in 1 million chance that it is somebody else.
And to do anything like that with tool mark, you would have to quantify the similarity and differences of the tool marks.
And that's what I'm getting at, is all of that goes to the application of the theory, I think, not to the abstract validity of the theory.
Absolutely, and there could be a day that with computers or AI that you can quantify and do something differently. But right now, having somebody eyeball it and say they look pretty similar to me, I think they're the same, that's not a reliable application of the theory. It's totally subjective. It's not quantified in any way, and it's certainly not something that could be subject to any sort of
I wasn't trying to get you to concede that the theory is valid. I was really just trying to focus in on the importance of an explanation of how the theory is applied in an individual case. Thank you.
No further questions?
Hearing no other questions, Mr. Barber, thank you so much. And
Thank you, Your Honor.
On behalf of the entire court, I want to commend excellent counsel on both sides. Thorough, detailed briefs, very helpful to the court and its staff. That is combined with arguments that reflected a commendable command of this lengthy and complex record, together with applicable law. And it has all resulted in excellent arguments today. You've represented your respective positions professionally, and we all on the court commend counsel for both sides. We are adjourned.